Honorable guest of honor, former Justice Islam Chaudhary, Honorable guest of honor, learned senior advocate and barrister Azmalul Hossain KC, distinguished guest, respected client, learned advocate from Supreme Court, our advocates, Assalamu alaikum and good evening. I'm especially grateful for our guest of honors to be present among us because both of them are very busy person. Thank you for sparing some time amongst us. We would also like to thank our guests for spending this evening with us. For me personally, it is an exciting event because I have my pupil master or my senior, as we call in High Court, is amongst us, Azmalul sir. He is I started work with him after finishing my law from UK. So I joined his firm. I'd love to take you down the memory lane a little bit. As I finished my bar in 2003, I returned from UK and I was looking for a good law firm, a good senior to work with. I discussed with my father. He has actually could not give me any recommendation, but he said, let me take you to your dada. I said, oh, dada. And then yes, my grandfather and Mr. Abul Hassan Mahmoud Ali, honorable former foreign minister. His father and my grandfather used to work together in Dinajpur. So he took me to his house and he just retired from his foreign service. He was a foreign minister and he was he served in UK for 1996 to 2001. Probably he was in good touch with Azmalul sir. So he actually asked me whether you were interested in litigation or arbitration or not. I said, of course, I had no idea. I mean, what should I practice? Of course, as a lawyer, new lawyer, litigation, arbitration seems to be a good idea. So actually took me to his chambers. He was saying an associate in Mogbazar, and sir was there. Sir was also very busy, and he used to practice in England and Bangladesh. And learned senior's father, Asrarul Hossain, barrister. He was also a very renowned lawyer in Bangladesh. A few years back he expired, and QC sir is kind of carrying the same legacy of A. Hossain and Associates at that time. Sir agreed to accept me as his junior, and it was a very challenging thing. At that time I was kind of hearing different story from the colleagues. One of my colleagues used to sit next to me, Sami Sattar, now president of DCCI, and a senior colleague Saifullah Mamun, why they're supposed to be here. And I was hearing a lot of scary stories that whether I will be able to survive, but luckily I survived. After 6 months, I joined as a pupil. Then after 6 months, I became an associate in his firm, and I now understand that how difficult for him at that stage to go through my inexperience, all the writings and drafts, whatever I prepared, he was caring, and he took the the pain of taking care of all the things I prepared, also guide me, particularly with marshalling of facts, and we learned how to prepare chronology for the first time, and then how to prepare, do legal research, and then how to analyze, and he has to discuss with sir sometime, and I always every time get a new idea from him. Anytime I discuss a particular case with him, he always gave a new idea, and then I had first time under his leadership, I learn the lawyers not only do litigations, they also have like other works, like they work in the projects, they work legal projects, they work as an arbitrator, they represent as arbitrator, they also represent clients before different tribunals, and they provide non-contentious consultancy, legal opinion. So for me it was the new learning for me. Then I was alhamdulillah, I was absolutely fortunate to be with him. Whatever we learned in bar is truly reflected in the chambers. The work ethics and the quality of the work was absolutely outstanding. Alhamdulillah, it was, thanks to his blessing and learning, we have Rahman's chambers went down a long way already. 16th year, we are celebrating our annual dinner today. And this year our firm has been ranked for 4 departments have been ranked by world's leading legal directories, chambers and partners for corporate finance, for dispute resolution, for projects and energy, and also for what else? Yeah, and probably. Yeah, so and then construction, yeah, and also we have 6 lawyers team. We have a department, and we serve in district court. We also serve in taxes and VAT customs tribunal, labor court, and of course high court. Most of our district court and tribunal works are handled by our judicial branch, and we from High Court and the Supreme Court we work for the High Court matters, and we do have a branch in Chittagong, and from there we serve for the Chittagong related district court services. And however, none of them is much interesting compared to the achievement that SAR have, and we are going to definitely hear about both of our guests of honors. And I'm also going to add about our guest of honor, Mamun Chaudhary, Honorable former Justice. He is, he is kind of a beacon of justice to me, because he is so humble and very much cooperative. I had the opportunity to appear before his court a few times, and my greatest experience to work with him was to work as a co-arbitrator, my very first arbitration, and Sir was extremely helpful. And for me, it was a of course, the learning how to deliver a judgment. We used to work as a lawyer, but under his leadership and guidance, I learned particularly how to work as an arbitrator. Ladies and gentlemen, we will be hearing from honorable guests of honors, and we will be also honoring to our colleagues, peers and clients for what they deserve. And there is a book launching event also, and other than that, thank you again for coming and joining us. Hope you will enjoy the rest of the evening. Thank you.
Guests of honors, distinguished guests, ladies and gentlemen, Assalamu alaikum, and a very good evening to you all. We welcome you all to our 16th anniversary annual dinner. Thank you for making time to attend our humble gathering. I am Qazi Nazifa Islam, and I will be taking you through today's event. Now Mr. M.D. Ashari Islam, Associate of ADR, Land and Tribunals team, will say a few words about the guest of honor, Honorable former Justice Mamun Islam Chaudhary.
And a very good evening to you all. It is a great pleasure to be able to say a few words about our guest of honor, Mr. Mamun Chaudhary, Honorable former Justice of the High Court Division of the Supreme Court of Bangladesh. Mr. Chaudhary completed his BA Honours, MA in English and LLB under University of Dhaka. He joined in the judicial service as Assistant Judge in 17th March 1982 and served in the Ministry of Law, Justice and Parliamentary Affairs as Assistant Secretary from 1984 to 1988. He was trained as a legislative draftsman in Dhaka under the Commonwealth Fund for Technical Cooperation of the Commonwealth Secretariat, London, UK in 1984. In due course, he was promoted as District and Session Judge on 1st March 1998. Mr. Chaudhary was elevated as Additional Judge of the High Court Division. Mr. Chaudhary was elevated as Additional Judge of the High Court Division on 23rd August 2024 and appointed as Judge of the same division on 23rd of August 2006. As all good things must come to an end, Mr. Chaudhary, one of the most senior judges of the High Court Division of the Supreme Court, retired from his 38 years of judicial career on January 9, 2020. During his tenure, he was passed several landmark decisions. Presently, Mr. Chaudhary is involved as an arbitrator in a number of local and international arbitrations. Mr. Chaudhary, during his judicial life, participated in international seminars, conferences, workshops in Australia and Thailand, and also participated in sharing of views and experiences with Canadian judges in Ottawa, American judges in Newark, Malaysian judges in Kuala Lumpur, and Filipino judges in Manila. He was also visited India, Saudi Arabia, and United Kingdom. Ladies and gentlemen, put your hands together for Mr. Justice Moinul Islam Chaudhary.
Respected guest of honor, Mr. Rahman Hussain Kasim, King's Counsel, distinguished guests, ladies and gentlemen. I deem it a privilege to address this august congregation in this pleasant evening. As you know, law is by nature a mixed concept and has often different and complex philosophies. Yet, law is one of the deepest concerns of the civilized humanity because it offers protection against tyranny and anarchy. But in spite of coexistence of various legal philosophies, the concept of law is more easily understood than defined. Over the years, the legal philosophers have disputed and the lawyers have debated as to the meaning and purpose of law. According to Edmund Burke, law and arbitrary power are in eternal conflict. The purpose of law, as I understand, is the success of justice. Judges are charged with saying what the law means. When they speak, the force behind the law begins to operate. But you see, the judges cannot establish the rule of law single-handed. The other concerned agencies and stakeholders must play their due roles in this regard. Otherwise, establishment of the rule of law will remain a far cry and a piece of music of the distant drum. Anyway, I take this opportunity to say a few words about the bench and the bar. It is often said that the bench and the bar are the two sides of the same coin. They go hand in hand. Both the judges and lawyers are imbued with the same jurisprudential ideas, albeit their roles are different. So in that view of the matter, any propensity of either side to carry its temporary ruffled feelings against the other to an unreasonable length destroys the moral foundation of both institutions. So the judges and the lawyers must be on their guard to see that the moral foundation of the bench and the bar is not destroyed in any manner. You see, our people crave for quick and inexpensive justice, but their craving has largely remained unfulfilled because of the complex, complicated, and cumbersome procedural laws and backlog of cases. Simplification of the procedural laws is the job of the legislature. You know, we have inherited the present judicial system from the British. This Anglo-Saxon judicial system, I must say, has become outdated and outmoded to some extent with the passage of time. So it needs to be overhauled. I think the days are not far off when the lawyers, judges and jurists will sit together and evolve a new mechanism for delivering prompt and cost-effective justice to the litigant people. You see, the confidence of the people in the court depends upon the quality of justice it administers. The higher the quality of justice, the more the confidence of the people in the court. The best judgment of the court is the product of the finest submissions made by the bar. But unfortunately, there has been deterioration all around, affecting the quality of justice. According to the observation of the Indian Supreme Court in S.P. Gupta's case, the lawyers are equal partners with the judges in the administration of justice. So the role of the lawyers in the dispensation of justice is no less important than that of the judges. You see, it is often said that the life of a lawyer is not a bed of roses. If he is successful, it is all bad, it is all roses and no bad. And if he is unsuccessful, it is all bad and no roses. Lord Denning, in his book, The Discipline of Law, has said, books are the tools of trade of a lawyer. So a lawyer must have a rich library of his own, because books are the tools of trade of a lawyer. A judge, you know, must be made of sterner stuff. A judge is a judicial craftsman of this craftsmanship. The best guarantee of justice, impartiality and depth of knowledge of the judge concerned. I have the firm conviction that by dint of his unquestioned, a judge can still command unwavering and unflagging respect from the people in general and the members of the bar in particular. You see, in the day-to-day judicial work, judges are often faced with two self-contradictory, self-defeating, and paradoxical legal dicta. That is to say, justice delayed is justice denied, and justice hurried is justice buried. In my humble view, a fine balance has to be struck between the two, paving the way for dispensation of justice on time. You know, the proverbial delay in the disposal of cases is a matter of concern, no doubt. You see, in Bangladesh, the logjam of cases is a perennial problem. The phenomenal growth of population is primarily responsible for a plethora of cases, thus compounding the judge case ratio is very adverse in Bangladesh. In late 1980s, I was posted as Joint District Judge in Dhaka Judgeship. In those days, I had to work from 9 a.m. to 9 p.m. you see, in all, there are about 1,900. That is to say, 1,900 judges and judicial officers. In Bangladesh, to cope with the huge backlog of 5 billion cases. There is 50 lakh cases, 5 billion cases. Given this scenario, fresh appointments of judges in all courts of the country are an imperative necessity. Precisely speaking, the number of judges must be increased rationally and proportionately in view of the huge workloads in the courts of the country. In our country, judge-initiated mediation is a must for quick disposal of civil cases and appeals. Judges must take the initiative in this respect at pre-trial stage and before commencement of hearing of appeals. In fact, the settlement of court cases through judge-sponsored mediation has helped the courts in tackling the wave of cases and keeping the civil justice delivery system functional and effective both in Malaysia and the Philippines. But in Bangladesh, though mediation is a resounding success in family court cases, it is yet to take firm roots in other civil cases. In order to reduce the backlog of criminal cases, plea bargain mechanism may be introduced in our criminal justice delivery system as in the United States of America. Besides, more offences may be made compoundable under Section 345 of the Code of Criminal Procedure. Over and above, judicial magistrates may be advised to proceed against the complainants and informants of false and frivolous or vexatious cases under Section 250 of the Code of Criminal Procedure. Like Malaysia, we should introduce e-judiciary in Bangladesh. This will enhance transparency, reduce irregularities, and eliminate unnecessary delay in the justice delivery system. A system of continuous and stringent monitoring and supervision of the performances of the judges, judicial magistrates, and court employees must be in place in Bangladesh. With that end in view, some senior judges designated as supervising judges or executive judges may be appointed to monitor the performance of other judges and to see that the court time is fully utilized by them. Our judges have been dispensing justice through litigations over the years. In spite of, many constraints, they have been toiling day in, day out to dispose of the pending cases. I am really proud of them, and I also pay homage to them, because there are you'll see many inadequacies, many loopholes in the judicial system. There is a lack of infrastructural facilities in some districts. Even to my knowledge, 3 judges shared the same ajlash by rotation. You just conceive of this situation where 3 judges share the same court by rotation and try to dispose of cases. These are no doubt hiccups. Ours is a developing country. We have, our resources are limited. There are many constraints. Even then, they are doing a good job by dispensing, justice to the litigant people. Although I am a retired judge, the judiciary is my passion. I always feel happy, energetic, and rejuvenated in the midst of judges and lawyers. Before I wrap up, I express my heartfelt gratitude to Mr. Rahman for inviting me and affording me an opportunity to say a few words here. Thank you very much. Thank you all.
Rahman, Senior Associate and Deputy Head of International Department, will give a brief introduction of our guest of honor, Mr. Azmalul Hussain, King's Counsel and Senior Advocate of Supreme Court of Bangladesh.
Alaikum, and a very good evening to you all. It is with great pleasure that I am able to say a few words about our guest of honor, Mr. Azmalul Hussain, QC Sir, the first ever King's Counsel in England of Bangladeshi origin and Senior Advocate of the Supreme Court of Bangladesh. Mr. Hussain completed his LLB honours and LLM from King's College, London. He was called to the Bar of England and Wales in 1976 from the Honourable Society of Lincoln's Inn in London. He got enrolled in the High Court Division of the Supreme Court of Bangladesh in 1977 and the Appellate Division of the Supreme Court of Bangladesh in 1986. He became a Senior Advocate of the Supreme Court of Bangladesh in 1998, and in the same year he was appointed as the then Queen's Counsel, as it was back then known, of England and Wales. Mr. Hussain is also a registered foreign lawyer of Singapore since 2007. He has been serving on the panel of arbitrators on the Brunei Darussalam Arbitration Center, South Asian Association for Regional Cooperation, Shenzhen Court of International Arbitration, Bangladesh International Arbitration Center, the BIAC, the Kuala Lumpur Regional Center for Arbitration, and the Singapore International Arbitration Center, known as SIAC. He is a certified international arbitrator of the Asian Institute of Alternative Dispute Resolution, a fellow of the Chartered Institute of Arbitrators in London, members of the ICC Commission on Arbitration, Paris, adjudicator in construction industry payment disputes in Malaysia, and also previously was a member of the ICC Court of Arbitration. Sir is also an experienced advocate in multiple jurisdictions, appearing before the High Court and the Court of Appeal in London, the High Court and the Appellate Divisions of the Supreme Court of Bangladesh, and also in domestic and international arbitrations and mediations. He has also been practicing from Selborne Chambers in London, where he's also a senior partner at A. Hussain and Associates, practicing in Bangladesh and Singapore, and A. Hussain Sarl in Geneva. Mr. Hussain contributed with his excellent arguments and submissions before the higher courts in England and Bangladesh, which resulted in numerous landmark reported cases involving different areas of law. He also acts as an arbitrator and mediator in cross-border and domestic disputes and sits on the disciplinary panels and tribunals with specialist knowledge of litigation arbitration and ADR, multi-party actions, cross-border disputes, debt and security recovery, commercial fraud, regulatory and fiduciary obligations, commercial documents, and also financial contracts. He has acted as sole arbitrator and co-arbitrator in several domestic and international institutional, trade, and ad hoc arbitrations. References include ICC arbitrations on contractual disputes concerning several multi-million-dollar power projects and multi-million contracts for the supply of aircraft, and a sole arbitrator appointed by the LCIA on multi-million claim on a guarantee, as well as co-arbitrator in the SIAC dispute relating to energy generation and waste disposal. He has experience of acting as counsel in arbitrations and mediations under institutional rules, including ICSID, ICC, LCIA, SIAC, GAFTA, FOSFA, LMAA, RSA, PORAM, and ad hoc arbitrations involving high-value and multi-party cross-border disputes involving governments, multinational, and domestic entities. He has also acted as counsel for and against banks, financial institutions, corporations, and others in many complex and high-value litigation, arbitrations, and mediations. Cases include claims arising out of transnational banking, trading, supply, and financial contracts. He has also acted as senior counsel in ICSID arbitrations for and against Bangladesh, including a bilateral investment treaty dispute, and for a multinational gas exploration company in a dispute concerning a gas field blowout. He has also acted as senior counsel for corporate clients in several institutional and ad hoc arbitrations in the financial, energy, and telecommunications sector. He has successfully challenged the Fifth Amendment to the Bangladesh Constitution, declaring martial law illegal, acted as amicus curiae in the Bangladesh Supreme Court in several high-profile constitutional cases, including the case concerning the 7th, which is the illegal military regime, the 13th, which deals with the caretaker government, and the 16th Amendment, Forum for Removal of Supreme Court Judges. As well as having expertise in the laws of England, Bangladesh, India, Pakistan, the European Union, and Singapore, he has also been involved in the drafting of several regulations and proposed amendments to the Arbitration Act of 2001. In Bangladesh, 2001 in Bangladesh, provided expert opinions. He has also provided expert opinions on the laws of Bangladesh, India, Pakistan, England, and the European Union, and has also appeared in the courts in North America, Europe, and Asia as expert witness. Ladies and gentlemen, without further ado, please put your hands together for Mr. Ajmalul Hossain QC sir. Yes, sir. Now on the stage. Thank you so much.
Honorable guest of honor, Justice Mamun Chaudhry, our host, Muhammad Rahman, barrister, and distinguished ladies and gentlemen. It's an honor to be here in your presence this evening. Farooq, I have known for a very long time. As he said, going down memory lane, he started with me after he'd come back from England as a pupil. And at that time, I was doing a project for the central bank. That was the only time that I actually filled up a form and participated in a tender to be appointed as a lawyer, you know. And so that was the only time in my life, and I somehow managed to get it. And Farooq was on my team, so he was always resident in Bangladesh Bank. I used to come and go. There were others in the team. There was a French company, a lawyer who was there. There was an Indian lawyer who was there. So we were a team of international lawyers helping Bangladesh Bank to become independent, use its autonomy in the right way, and Farooq, I know him from that time. He worked with me for many years, and obviously I must tell you that he was one of the brighter ones that worked for me. And of course, I can tell you this brightest will start looking for their own engine and become an engine driver. They do not want to sit behind the engine driver and just sort of put something there. You know, they want to drive their own engines, and he's done that. Justice, and my chambers used to be in my father's residence, and it was a chamber which was set up by him more than 75 years ago. And at one time I used to stay there, and I used to meet Justice Chaudhry in the mosque. We used to go and say our Jummah prayer in the same mosque. But apart from that, I saw him many times, of course, appeared before him in the High Court division. And one of the cases that he and I disagreed with, or rather he disagreed with me, was the 16th Amendment case. So that was a case which relates obviously to, you may have heard of it, this relates to the removal of judges under the constitutional remit. So the process for removal of judges, originally in the Constitution it was down to the Parliament, members of Parliament removed. Then it was amended, and the Supreme Judicial Council was established. And then in the 15th Amendment, there was a change made, and it was that change which came before the court. And the court decided that the change was not justified. I supported the amendment, but their lordships decided against us, and of course as lawyers we have to accept what the judges say, and although we appealed, and also in the appeal we lost, the judges were upheld. So that is the law at the moment. There is a review pending at some point in time soon. I hope that the review will be heard and the Supreme Court will finally decide on the matter. Now, I have been asked by Farooq to speak alternative dispute resolution. And I'm conscious of the fact that I stand between you and dinner. So, I do not want to make my address to you too long, but I hope I can keep you entertained for a little while. Now, one of our colleagues, Mr. Mamun, very well-known senior advocate at the bar, he always used to say that ADR in Bangladesh means additional dispute resolution, not alternative. Effectively, he used to say that because under the old system, there was a lot of intervention in the arbitration process by judges and the courts. And a lot of time unhelpful intervention, if I may say so, with respect to His Lordship sitting here, because I'm sure in the course of the time that he spent on the bench in the High Court Division, he dealt with some of these arbitration matters as well. But that intervention really came from the fact that we had the old Arbitration Act of 1940, which was an act which was enacted by the English Parliament during the British times, 1940, following one of the laws made for England at that time. Now that act, obviously in those days, did not think about arbitration as an international phenomenon. Most of the arbitration that took place was domestic. So it was in one jurisdiction only, and it had provisions for appeal, challenging by way of an appeal and so on. That changed when the UNCITRAL model law came in, and the UNCITRAL model law suggested changes to the national statutes. And what we did in 2001 was amended, in fact, got rid of the old Arbitration Act of 1940, and we have our new Arbitration Act of 2001, following the UNCITRAL model law. So this is a standard form of legislation which is prevalent now in most of the world, and caters for international dispute resolution. And that is where we come in now, and we are trying to use arbitration and mediation and other forms of alternative dispute resolution to augment the system that already exists in every nation, particularly in Bangladesh, for a dispute resolution. And the intention is basically to make access to justice easier, and for parties to have their disputes resolved without going through a hostile litigation in open court. So that is the objective. Now, in this context, what I'm reminded of is that some years ago, about 30 years ago, in England, there was a report prepared by the Master of the Rolls at that time, Lord Wolfe. And he called it Access to Justice. And he identified his remit. His task was to look at the English justice delivery system and suggest changes, civil justice delivery system, and suggest changes. He identified two evils in the English justice delivery system. The first one was delay. Everything took a long time to resolve, which is not unusual. We come across it every day in our practice here. And the other one was cost. It was very expensive. So he tried to address those two evils. In Bangladesh, we have two more evils. One of them has been referred to by my Lord Justice Chaudhary, vexatious litigation, abuse of process. And the second one is multiplicity of proceedings. The normal problem that we face with the delay in the justice delivery system, everyone attributes that to the increasing number of people, population, less number of courts, and the fact that the system is to a certain extent old and archaic, which encourages delay. But the real difficulty, and I find this every day, and yesterday I was preparing, one of my juniors is here, he was there, in fact he was there this morning, and I was preparing the case, and I find that there are 17 sets of litigation, 17, one set, to resolve one dispute regarding one piece of property. 17. And I have found that most of the cases that I do relates to the banking and finance industry. And I have found that wherever there is a case relating to one loan, the parties end up with at least 17 or 18 cases. So if you have 17 or 18 cases which resolve one dispute, then you can imagine why the courts have a log jam, as Justice Chaudhary said. So I think the reason for that is the multiplicity of proceedings and a lot of abuse of process. And we see that every day, unnecessary litigation being brought in. Now, if you move away from the courts and go towards ADR, you are contractually bound to resolve your dispute in a particular manner. So you've got to deal with it either by arbitration or by a tiered dispute resolution clause. We call it a tier because the first tier may be negotiation, second tier may be mediation, third tier may be arbitration. So you have it resolved by an alternative method away from the courts. And the advantage of this is that it is not in the open, not in the public domain. So it remains confidential between the parties, and you can direct the pace depending upon which arbitrator you've got. Because litigation in our country, in my view, is not really driven by the clients or by the courts. It's driven by the lawyers. See, if the lawyers want to drive it fast, they can. If they don't want to drive it fast, they can also do that. And they can hold back that line. For whatever reason, that is what I find to be the situation. In England, Lord Wolfe ensured that the courts take case management as an important factor in resolving disputes. So the courts actually take the procedural thing in their hand and have case management conferences to make sure the case is proceeding in the way that you want it to proceed for an early resolution and as cheaply as possible. Now that is not happening in Bangladesh, because we need some changes in the law to achieve that. But if you want to go for ADR, you can easily do that. The arbitrators can do that. I know for a fact that I recently did, in fact, Farooq was representing one of the parties, and he used to mediation, fast track arbitration under the BIAC rules, which has to complete within 90 days. So I was appointed the sole arbitrator, and I took on the job, although it's not that lucrative, but nevertheless, I said I'll do it to set the standard. And I did it in 90 days. So from start to finish, the whole dispute was resolved in 3 months. So if one wants to do it, that can be done. And I had a case, historically speaking, I had a case in Dhaka where a vessel was actually arrested. And it was sitting somewhere in the Bay of Bengal, anchored, could not go away because it was arrested. And there was an arbitration clause. So I sent a notice of arbitration on the SEAC rules, I think on the 2nd of January. And in that case, we had an award on the 1st of April. So we've developed a fast track process, because every day that vessel was in anchor and arrested, it was causing the parties a loss of $10,000 per day. So it was a huge amount which was increasing day by day. So it can be done. So it depends upon a proactive arbitrator. Rules must be flexible enough. And if the parties want to have their dispute resolved, they can do it in a short time. And they can do it confidentially. There's one thing that I want to add in this context, which is that today, the public policy of Bangladesh, I would say, encourages ADR. If you look at the historical position, 20 years from now, before, in the year 2003, the Civil Procedure Code was amended. The Civil Procedure Code was amended to add several provisions relating to ADR. One was to encourage mediation, and the other one was to encourage arbitration. And why do I say that it's part of the public policy? Because since then we've had many other acts, and you're through another of nine, Tax Act, the VAT Act, Customs Act, all of them encouraging disputes to be resolved by alternative means rather than going through the due processes. So as a result of all of these changes, it can be argued, and I have argued on many occasions before the Appellate Division, that this is part of, ADR is now part of the public policy of Bangladesh. And the judges have accepted it. And I remember one Chief Justice saying to one of the parties who wanted to challenge arbitration, saying, a contract করার জন্য আপনারা লিভারপুল যেতে পারেন, তো dispute resolution এর জন্য যাবেন না কেন? So this was obvious, you know. So the mood is changing. So from the old days where we had the intervention of the courts coming in, that is now stopping. So it's a move in the positive direction. So obviously, I think, and I'm being an ADR practitioner, I think this is probably the best way of resolving disputes. Mediations are very helpful because businessmen normally want to carry on with their business. Dispute resolution is not their business. It may be our business, but it costs them money, time, resources, everything. So for them, the sooner they get out of it and they carry on with their business, the better for them. So my view is that mediation certainly is a well-known phenomenon, and which provides a lot of, I think, high rate of success. And I can tell you this, at one point in time, I was in England. I had a diary, my diary was full for 6 months, pretty much. I knew back to back, I had several cases. And then of course the wolf changes came in, and we had to go to mandatory mediation. Now all my cases evaporated, all gone, because they're all settled by mediation. 6 months were gone. Now of course I had a little bit of a role to play. It was not dispute resolution through the court, but in the mediation also I appeared on behalf of the client and got some money out of it, but not as much as I would have if I did the cases throughout that period. So at that time I started coming to Bangladesh, and that was the time when we were getting into mediation as well. And there was a lot of concern by the lawyers saying, oh, if we go to mediation, what will happen to our work, what will happen to our business? But you see, in mediation also lawyers have a role, together with the mediator, to resolve the dispute. And of course, this is a consensual way of resolving disputes. And the idea is that both parties go away on a win-win basis. That's the general idea. Now in hostile litigation, you never get that result. Even in hostile arbitration, you don't get that. So there are many forms of alternative dispute resolution. You can have mediation, you can have expert adjudication. Sometimes someone goes to a lawyer and says, can you please give me an advice on this? Both parties say, whatever advice you give, I will follow. Both parties agree to follow that. So you have it like that sometimes. And these are the ways in which you can expedite the resolution of disputes. The other way, of course, is dispute avoidance. This is something that you have to anticipate, that if you are likely to end up with a dispute, how to avoid the dispute. And at the right time, when the big parties are still friendly and are talking, that is the time you want to engage and try and see if you can avoid the dispute altogether, not go to a lawyer and finish it, or even go to a lawyer and still finish it. So that is the sort of thing that businessmen really want. They want to get on with their business. They don't want to litigate, they don't want to arbitrate or anything. So if the solution comes in a way which avoids litigation, my suggestion and my advice will be, please take that. With that, thank you very much. I will end my speech.
For your informative words. Now we will be moving to our book launching ceremony, and for that we call our head of chambers, Rahman.
This is the book. It's not a book actually. We have been, since the farm started, I used to encourage our colleagues to write something. We had a meeting, HR meeting every month, and every month meeting I encourage them, why don't you write something, whatever you're learning, through practice, write an article. So this is a compilation of article of 15 years, from 2006 to 2021. And we used to publish it in a newsletter. Every year we publish 2 newsletters, and every newsletter have articles, some written by me and some written by some other colleagues. And many of them are not here with us, but the articles remain with us, and then we published all together. And we compiled it in a department wise, but originally when we published in a newsletter, we actually published it as it comes, like everywhere we added 2, 3 articles, 4 articles, and then whenever we learn something through practice, or someone has special knowledge because of the education, probably attended a LLM course and have some specialization on some particular topic, they wrote an article, and same happened to me also. So then we compile all the article in this book. If you see that there are 9 departments which are actually our practice department now we are doing. So we have compiled it under the 9 heading: corporate, commercial, investment, dispute resolution, construction, project and energy, international, taxes and finance, information technology, shipping. All these 9 department articles are organized as per the department, but this has been published throughout the year since 2006. So ladies and gentlemen, our honorable guest of honor, Justice Mamun Islam Choudhury, and guest of honor Rahman Hussain KC sir, both of them have written their nice words as a foreword in the book. I would request them to kindly put their signature on it as a opening of the book, launching of part of the launching of the book. Sir, please.
Thank you.
Thank you so much, sir. I want to request my editorial team who have participated in publishing the book, Abdul Rahman Zunaid, our advocate and senior associate who works from Motijil, and also Monir Hussain to come here, join with me to hand over a complimentary copy of the book to our both guest of honors. Sir, if you like, you may say something about the book, sir. If you say something.
For this gift. I think it's a gift not just to me, but to all of us here and to the rest of our community. It's a wonderful thing to do because we do write many things, make us written submissions and stuff like that. When we have our little thoughts, and we never print it and publish it. So it's a good thing to do, and I'm sure a lot of people will find it useful. Thank you very much.
Thank you.
I have a cursory glance at the book. It is virtually a compendium of some articles written by Mr. Rahman. Hopefully, this book will be, gone through by all interested readers, and they will be benefited by it. Thank you very much. Thank you.
Will all the guests participated here at the time of dinner. Thank you so much. Thank you.
Now we will be moving to our presentation ceremony. Mr. Say a few words about the winner of the Rahman's Chambers Award 2022 from our investment department.
Premium lifestyle products in 5 categories: apparel, footwear and accessories, home, fragrances and hospitality. For more than 50 years, they have sought to inspire the dream of a better life through authenticity and timeless style. Their reputation and distinctive image have been consistently developed across an expanding number of the products, brands and international markets. We have assisted them in incorporating their local subsidiary in 2019, and since then they have made significant amount of investment in Bangladesh. Ladies and gentlemen, we request Mr. Justice Mamun Islam Chaudhuri to kindly announce the name of the winner.
Ralph Lauren Sourcing Bangladesh Limited for
Miss Sultana Shakila Mandan is kindly requested. Please.
Of Shipping Department will say a few words about the winner of the Rahman's Chambers Award 2022 from our corporate department.
Good evening, ladies and gentlemen. This year's winner from our corporate department, although founded in 1999, has become a pioneer in residential, commercial and shopping mall development as well as land subdivision development. With its headquarters now located in Dhaka, they have grown rapidly in stature due to their pioneering, innovative and sustainable approach to real estate development. They are the world-class company fully committed to making life better. By always partnering with renowned professionals across different fields of expertise, they have always ensured the delivery of projects on time in full. They have a team of dedicated and passionate personnel who are dynamic, hardworking, efficient and a corporate culture, which is unlike any other developer company. Ladies and gentlemen, we would like to request our honorable guest, former Justice Mr. Mamun Islam Chaudhuri, to kindly announce the name of the winner.
Sanmar Properties and Corporate Culture.
We would like to request, ladies and gentlemen, please put your hands together for the winner.
MD Mamun Rahman, Manager of Accounts, will say a few words about the winner of Rahman's Chambers Award 2022 from our Taxes and Finance Department.
Thank you, Ms. Nazifa, for inviting me to say about Taxes and Finance Department. Award this year's winner from our Taxes and Finance Department is an Indian multinational conglomerate company with business interests in engineering, construction, manufacturing, technology, information technology and financial services. It operates in over 50 countries worldwide. A strong customer-focused approach and the constant quest for top-class quality have enabled it to attain the sustained leadership in its major lines of business for 8 decades. The company is counted among world's top 5 construction companies. Ladies and gentlemen, we request Mr. Justice Mamun Islam Chaudhuri to kindly announce the name of the winner.
I am happy to announce that Larsen and Toubro Limited will be given an award for being a major tax contributor in Bangladesh.
Mr. Nami And Mr. Doctor is kindly put your hands together.
Award for the year 2022 to our members. At first, we will be handing over the award for the best team of the year 2022. Ladies and gentlemen, we request Mr. Azmalul Hussain to kindly announce the winning team.
I'm happy to announce that the Chattogram team, comprising Ms. Tanzina Sharmeen, Mr. Muhammad Tawhidul Hassan, Mr. Abdullah Al Burhan, is the winning team.
They're working from our Chattogram branch for almost 3 years. They're working as a team before since the pandemic, and they have been consistently doing well. And they do provide important service for our clients, our respective clients, for shipping and corporate investment work, which is involving particularly in Chittagong. And Tanzina Sharmi, the advocate of Supreme Court, and Tawheed is the associate, deals with our corporate work mostly, and Burhan is our office manager. I would request them to come and take the award from Honorable Justice, former Justice Mamun Islam Chaudhary. Thank you.
Of the year 2022. Ladies and gentlemen, we request Mr. Azmalul Hussain to kindly announce the name of the winner.
The winner is Mr. Salahuddin Reza Sohel. Congratulations.
Are going on, and he has been working day and night for all over the year. Even Friday, Saturday, anytime he just, I found him working and he met the deadline. There was a huge requirement, pressure from clients to complete the work on time, and he's an excellent lawyer, particularly in that matter, so he definitely deserves it.
Over a crest of appreciation to our guest of honor, Honorable former Justice Moinul Islam Chaudhary, and for that we call our head of chambers, Muhammad Rahman.
Ladies and gentlemen, Lord Denny once said, the best judge is one who is less known and seen in the media. And this is perfectly, as a lawyer, we have our colleagues, our colleagues are here. We all know that how humble he was, and he is a person who believed in the office, and he put the office first, not himself. Always that is the case. And Honorable Justice Moinul Islam Chaudhary, we already hear about him. And personally, once the name of appointment arbitrator came, that we have been many a time work as a legal counsel for clients, and there's a time when we need to decide who should be the chairman. Once we propose his name, we have found it unanimously accepted by the lawyers. There is, irrespective of any the revisions, he is the name. He is accepted by every lawyer as a the true judge who is definitely deserves this award. Ladies and gentlemen, I would request Dr. Fozul Kabir sir Honorable former Secretary to come to, and also learned advocate and record, General Abidin Tohin Bhai, kindly, and if Nakib is here, no, kindly come forward and please hand over the award. So Nakib is here, Advocate Supreme Court.
Over a crest of appreciation to our guest of honor, Mr. Azmalul Hussain, King's Counsel and Senior Advocate of Supreme Court of Bangladesh, and for that we call our Head of Chambers, Muhammad Rahman.
As we have already seen that how persuasive and how good he can argue, there's no doubt about it. He has been convincing the court many years, and we have seen him appearing before the court. There is no end of learning. I always take the opportunity to engage him as a senior counsel, and whenever the opportunity comes, because he's always in a complex matter, he's an excellent lawyer, no doubt about it, and an arbitrator. In many situations, if you see the look back the history of legal development, the growth development in Bangladesh, he is the torch bearer of many things. Number one, he is the torch bearer for arbitration. The very first arbitrator we know is actually Azmalul sir, for sure. Not only that, he brought many concepts from England and argued before the honorable courts, and honorable court accepted it. For example, he, the legitimate expectation is a concept which was known to us, was in the common law, but never been tried before in Bangladesh court. Nobody argued it before him, and he is the very first honorable senior who put it through, and it has been accepted by the honorable courts. And not only that, in one of our own case, before Honorable Justice Abdul Rahman sir was the judge, he's thankfully present amongst us. He was, he put forward an argument that any case involving ship finance should not be tried in author in other words. It should be tried before the Admiralty Court. And that is the argument, pressed by learned senior and accepted by Honorable F.M. Abdul Rahman, former Justice F.M. Abdul Rahman sir. This is a landmark leading decision, not yet been challenged and still exists. Other than that, he brought the concepts of, minority protection, for the companies where the small minorities are fighting. He has got a number of leading cases involving minority protection and letter of credit. With all the disputes involving letter of credit, he has a number of leading judgments. And we already hear from our colleagues that his contribution about fundamental rights and bringing amendment in constitutional law, none of them he has done for his publicity. He has a client who he need to fight for him, and he brought, if he needed, he also took the risk of challenging the constitution itself, and many times he has been successful. Ladies and gentlemen, could you put your hands together for this, for him, and we are honored to honor him for outstanding service, and his contribution within the legal system. I would request Abdul Rahman, former Justice Abdul Rahman sir, to come to the stage to hand over the award, and also, if I may, our junior, sir, very favorite junior, and Misbah Rahman, Barrister Misbah Rahman, Advocate Supreme Court, and come forward. And
without having any transformation in the physics,
the Deputy
one
Attorney
QC
General
has
Mr.
become
Mamun.
case. That's what Azmalul was saying. Thank you. Yes. This is for you. So I'm happy to hand it over to you as a. One, two, three. Yes, this is the crest. That has been handed over to Mr. Stacy, Mr. Azmal Hussain. Sure. Is it? Thank you, thank you.
First, we will take our book launching photo.
It's my pleasure to have a photograph of
Very
all
nice.
of you.
Yes, sir.
He's a connoisseur of football.
Yeah, of course.
Ladies and gentlemen, thank you so much for spending the evening with us. Hope it was enjoyable. Let us now proceed for dinner. And special thanks to our guest of honors. Again, thank you so much.